If we could turn now for a moment to the sample requisitions on page 103. These have been included as merely that, sample requisitions. They are not intended to be the be-all and the end-all of requisitions arising from an examination of the abstract that you've been provided with. It's virtually impossible to prepare a requisition letter from the abstract that you've been provided with because without the benefit of conveyancer notes as to greater particularity for these instruments, the title could go off in any number of different directions or tangents. So what I've simply done is prepared certain sample requisitions, giving you some idea of form, perhaps in certain situations, some idea as to content and how to deal with thorny situations. On page 105, for example, I've referred to an examination of the plan, and this may be of some concern to your client if his legal access is barred to his house because certain one-foot reserves have not been lifted. I think it's often a situation when we are buying a house on a plan of subdivision is that we search the house and almost disregard the plan of subdivision itself, but that should be part and parcel of your search. Another example of a particularly difficult situation is requisition number 12, which deals with a potential Planning Act contravention. And I've taken some care to go through each of the instruments step by step and, in fact, do a little preamble or explanation as to why I consider the particular sequence of registrations or lack of information provided, leaving us with the possibility of a void title. So these requisitions are intended as sample requisitions. Immediately following are several requisition letters themselves that were used on particular transactions. One was a condominium purchase, and I include these to give you some indication of, once again, form, grouping of requisitions. Firstly, the title matters, and secondly, the more general matters, the particular pieces of legislation that you require compliance with. The third example of a requisition letter having to do with the cottage purchase in the township of Georgina has to do with the lovely purchase of a cottage by the Cohen family. And if anyone would like to see me afterwards about purchasing this particular cottage with these particular title problems in the township of Georgina, I'll be available. But you see how once again, how the requisition letter has been structured with some great particularity. Having requisition number 2, for example, deals with the step-by-step requirements of the various restrictions. In this particular case, very few of these requisitions were satisfied, and the client delivered instructions in writing to waive these requisitions. But you see again, the letter follows with a catch-all at the end, your checklist, after your title matters have been dealt with and everything has been structured. I was going to then turn to the abstract itself, but I think you've probably dealt with that at some length in one of your prior lectures by Rick Angelson, and I see that I'm just about running out of time. So I ask of you all, in conclusion, that in future, whenever I call any one of you, request an extension of requisitions, please grant it without consulting your clients. And please respond to me fully, and please remember the definition of laches. Thank you.
Thank you very much. Oh, he's got one more word.
I got one more word. I brought something to show you. Miriam didn't believe this, but this goes in the Guinness Book of World Records. This is a requisition letter that I'm very proud of. I carry it with me everywhere I go. It arose from a transaction that I completed last year. It was an $80 million financing of 250 properties in 7 provinces across Canada. And this, believe me, is a requisition letter. And the instructions from the client to waive was thicker than this.
And I bet you got 7 extensions. I was wondering what he was going to do about that widow of John Fastback, Irma. Nobody seems to be worried about her dower interest, though I noticed you did mention that if she stayed on the premises, which this gal seems to have done, she might still have her dower. Well, we'll have to see what Pat does with that after our 2-second break. Now we're running a little short of time. I did promise you we'd be out by 7:30. Maybe tonight it'll be 7:30 Newfoundland time, because we're going to do now the crunch. Hold everything. We'll get everybody sitting down here. This is the crunch. This is the closing. Assuming that we've got a nice agreement, and assuming that we've been through our search, and assuming our client knows what our client is supposed to know about his title and his survey and his search and his requisitions, and assuming that everybody's got some money, we're going to work through the documents in your workbook. I think they start about 200, is it? 200 and something in your workbook. And Pat Drozdoski is going to help us work our way through these documents. And Pat is not only eminently qualified by virtue of her education at Osgoode Hall and her practice with a firm which bears a similar name to the one where Mr. Cohen now practices, but Pat, in her spare time, after looking after her husband and children, and that, by the way, is in 2 countries, she also finds time to practice law with a sole practitioner. I don't know how you do that and still be a sole practitioner, and teach. And she teaches this kind of thing at the Niagara College of Applied Arts, and so I guess for her it's duck soup. Let's listen to how we do it. Pat?
I'm going to leave the document preparation to the end and just go through very briefly my lecture. I hope very briefly. Many of the problems that arise on closing could be corrected, of course, I believe, by proper preparation. And we've all been through the pressure and tension of closing. And I hope that some of the procedures that I point out to you will assist you in reducing those tensions, and more than anything, assist in reducing errors. There is a theme besides preparation and organization through my lecture, and that theme is that we're trying to protect ourselves, and we're trying to do that kind of protection by anticipating what is required by our client rather than us signing things for our client. And I refer you to a young lawyer's materials on defensive real estate practice. I found them very helpful in preparing my lecture. I'd like to deal firstly with a sale and acting for the vendor, and particularly the preparation of materials. Generally, I have stated that you should try to have the statement of adjustments prepared as soon as possible. Your client wants to know how much money he's getting out of this deal, and of course you'll be endeared to the purchaser's solicitor as well. It has become the practice now for the purchaser to arrange his own insurance, and it is important that it be arranged prior to closing. If the vendor is taking back a mortgage, you're going to want a copy of the insurance policy showing his interest on that closing date. Even if the purchaser is assuming an existing mortgage, the vendor will want to have evidence of insurance so that he may obtain a release of interest and cancel his own insurance. With regard to directions, one of the most usual directions that the vendor will sign is the direction relating to the balance due on closing. And I point out that the balance due on closing should be made payable to you as the solicitor or as you may direct. Quite often, if the added phrase, "or as you may direct," is not put on, you're going to have your vendor reattend to further direct the funds. If the vendor has agreed to take a mortgage back in the agreement of purchase and sale for part of the sale proceeds, and then decides to put title to such mortgage in his name jointly or in the name of another, you will need a direction with regard to the title to that mortgage. Once the vendor advises how he intends to take title to the mortgage, the direction should be prepared together with the other documents that you will have available for his signature. Sometimes there's a tendency to wait on the part of the vendor's solicitor until you are asked for such a direction. Again, it's my experience that if you anticipate what is required, you save yourself from the possibility of having to prepare further material and reattend with the vendor. With regard to undertakings and that famous declaration of possession, as a general rule with regard to undertakings, it has been stated, quote, "avoid them as much as possible." And I did speak to Miriam with regard to undertakings, and it just seems that no matter which way you turn on a real estate transaction, you do end up having to give or receive undertakings in one form or another. We all heard about the 4 possible kinds of undertakings: the client's, the solicitor's personal undertaking, the solicitor's undertaking on behalf of his client, and that old best efforts one. Clients personally should execute undertakings required of them, and most importantly, they should do so with the full knowledge of their import. If you as the solicitor are giving an undertaking on behalf of your client, you should do so only on instructions from such client and ensuring that your client clearly understands the undertaking. Usually the use of an undertaking on behalf of the client arises during a frantic closing, where it may be difficult to reach the client for instructions. If you do reach your client for instructions, you should confirm those instructions in writing after closing. Therefore, my earlier statement to have clients execute prior to closing a statement of undertakings would be preferable. And we have all seen the normal undertaking that is usually given by the vendor on a closing, and there is one set out in your workbook at page 197. The undertaking with regard to delivering up vacant possession and readjusting the statement of adjustments and so on. I firmly believe that this undertaking should be prepared by the purchaser's solicitor to ensure that all the matters of his concern are covered and forwarded to the vendor's solicitor for execution by the vendor. However, in my practice, I prepare such undertaking when acting for the vendor in the event that the purchaser's solicitor may not, prior to closing, prepare same, yet obviously require one on closing and want me to give it. With regard to solicitors' personal undertakings, our insurers in their lectures have come down strongly and stated, do not give them. But there seems again at times no alternative, and I suggest to you that you give them with care. You should ensure that the person giving it can carry it out, that they have instructions from their client, that a time limit as to the completion is inserted. The most common form of solicitor's personal undertaking is the undertaking with regard to discharging a mortgage. The purchaser is entitled to have a discharge of mortgage registered on closing. Therefore, if the vendor cannot provide this and you intend to give a personal solicitor's undertaking, you should, well before closing, ask the purchaser's solicitor if his client will accept such an undertaking. From the solicitor's point of view, the one giving the undertaking, a risk arises where there is an error in the mortgagee's statement and the vendor refuses to pay the additional sum. Again, where there is a mortgagee who is an individual, there is no good reason for taking such risks, and through bridge financing, a discharge should be available on closing. With regard to solicitors' undertakings to use their best efforts, I think it should be remembered that mere token efforts are not enough, and you should be prepared to do some work with regard to that undertaking. I, as a policy, like Bob, prior to any request being made or declaration being sent by the purchaser's solicitor for execution by my client, prepare a declaration of possession for all registry conveyancing, whether or not there's a title problem and regardless of how long the vendor has owned the property. It has become the practice to use those pre-printed forms, and they save some time. But a pre-printed form, no matter how well prepared, does not apply to every situation. And you've all seen the example of the situation where your client signs the declaration of possession, swearing that the lands are entirely fenced and there's no fence at all. I think it's important that the declaration of possession be read by your client and amendments made to correspond to the factual situation. Otherwise, you're in a situation where you're allowing your client to sign a false affidavit. What about documents? The documents which must be executed by the vendor on a sale will include, of course, the deed, and in particular, the affidavit of legal age and spousal status. We're going to look at in a little more detail at that document, but I wanted to mention at this stage that the affidavit should have inserted, the one with regard to legal age and spousal status, an extra line, and that is that the deponent has read Section 1F of the Family Law Reform Act 1978 and then is making comment about his spousal status. How can he say, in fact, that he is or is not a spouse within that meaning of the Act unless he's read that meaning? You should also insert in the affidavit the fact, if applicable, that the parties, when they executed the attached instrument, were permanent residents of Canada. And again, language which could lead to confusion or falseness should not be used, such as, I am not now, nor will be ever in the future a non-resident. That kind of language should be avoided. An affidavit with respect to the Planning Act may also have to be executed by the vendor, and again, I warn solicitors not to execute those affidavits on behalf of their clients. Arranging the file. It is essential to review the file prior to the vendor attending at your office, and I suggested a review of the file 5 or 6 days before closing, going through the checklist, and you have an excellent one in your workbook, of the items that have to be done when acting for the vendor. Going through that checklist and completing or making notations of any incomplete items. You should also ensure that any outstanding requisitions have been arranged to the satisfaction of the purchaser's solicitor. Documents must be reviewed to ensure that they are capable of registration. If you're unsure as to how to prepare a particular aspect of the document, now, that is the 5 or 6 days before closing, is the time to phone the registry office or attend at land titles and obtain a pre-clearance check. And I refer you to that Bulletin 80019 to land registrars about not amending documents. Finally, the file should be arranged so that all of the documents to be executed by the vendor are on a clip or in a separate file labeled Documents for Execution. And I usually, on top of those documents, set up my little memo containing a list of points that I wish to ask or bring to the attention of the vendor. And one of my particular lists, as I noted in my lecture, is that I always make a big sign, obtain the key. I always seem to forget about that key. If the purchaser's solicitor wishes the key to be left somewhere else, I still insist on handing one key over on closing and instruct the vendor to leave the balance of the keys with the vendor's real estate agent or the vendor's neighbor, with some kind of specific instruction that the keys not be released until given authority to do so. As earlier stated, I insist wherever possible that the vendor attend at least 1 day before the closing day, excuse me, to execute the documents and go over the details of the conveyance. If there are spousal rights, the spouse in question will also need to accompany the vendor. 2 copies of the Statement of Adjustments, it's difficult reading one copy upside down, should be with the documents that he is going to be executing, and I go through each item of that statement with the vendor, explaining how the figure was arrived at and confirming that, in fact, this is his understanding of what has been paid. I also point out his responsibility in ensuring that each item that he was credited for is paid by him, and I point out that he will be signing a promise to readjust this statement if necessary. I also explain that the vendor is still on the covenant with regard to a mortgage being assumed by a purchaser, and that he may be so until the mortgage is paid in full. Don't think it's appropriate to unduly alarm the vendor, but I think it is our responsibility to explain his legal obligations. You'll note later that I do, in my reporting letter, if this is applicable, again confirm that he was advised that he still may be on the covenant with regard to a mortgage being assumed by the purchaser. After the statement of adjustments has been explained, then I set out individually each form that he must sign, and I think an explanation is deserved in each case. It doesn't have to be detailed, but a general explanation of the principal points. Definitely affidavits should be read over by him, and he should be assured of their truthfulness and meaning. I also think it's very important that the spouse of the vendor understand his or her rights and keep in mind maybe independent legal advice in some situations. The vendor is usually very anxious to know the amount of the funds that will be available to him, and an explanation of the fees and the disbursement should be given at this time in conjunction with a brief review of the work you have done. You have the file in front of you, and I think it's a good time to show the vendor that this is the kind of work you have been involved in. If you are aware of any future problems that might arise on the closing, without alarming the client, you should discuss these with him and obtain instructions now. You'll still contact him when and if the problems arise on the closing by phone, but he will be better able to understand what you're saying and to reaffirm his instructions. Most importantly, obtain the vendor's new address and phone number, and especially the phone number where he can be reached on the closing date. It is imperative that you stress the necessity of having him available on that date so that you can obtain instructions and moreover that he will be available to execute any further documents. Many vendors require the funds on the closing date, and you should ask to make sure if there is any rush with regard to when the funds be available for him. If so, you can then attempt to close the transaction early in the day, prepare a short report, and have your account ready ahead of time, just waiting for the check. We had a situation in our office meaning Bob and my office a few years ago, where it was very busy in the summertime. A solicitor was not advised until very late in the day that the vendor required the funds on closing. A hurried account and report was commenced, and the vendor left the jurisdiction. An error was discovered later, and it took a considerable time and expense to correct that error. Before the vendor leaves your office, it's wise to check all of the documents that he has executed to ensure that all the signatures are there. I know that seems very basic, but I'm sure that all of us have found ourselves sitting there with something unsigned. I also think it's imperative that you obtain from him at this point in time before he leaves any receipts for mortgage payments, fuel bills, taxes that he has paid within the last days before closing, because you will be able to hand those over on the closing date. What about the actual closing of the transaction, and in particular the closing memo? It is my practice to prepare a closing memo at all times, and this should be prepared, of course, before the file leaves for the registry office. The instructions in the memo can be very simple or very explicit, depending on the experience of the person who is conducting the closing. The closing memo is attached. I usually attach it to the outside of the file and have the items checked as the closing is taking place. Each item is given and obtained, and a further check is made, or any comments can be made or written onto this closing memo. Why do I recommend the closing memo? Simply because it ensures that no items will be forgotten, and furthermore, anyone not familiar with that file, with a very brief explanation, should be able to close that transaction and do a competent job. We all practice a little differently, and I prefer a specific closing memo for each transaction. The closing memo in your workbook, which I refer to as a long closing memo, sets out all the possible items that you would be required to obtain or give up. I usually use that as a checklist and prepare a specific memo, which I call short, for my particular transaction. You should insert, of course, in your memo the time of closing, the place, the phone numbers of the people that you're going to be closing with, and you should discuss with the purchaser's solicitor the list of things to be received and given up on the closing to avoid any surprises and the necessity of scribbling down undertakings on closing. What about receiving the documents and the check? Obviously, I think that most of us know these things, but I think I'll point them out anyway. Make sure you check the mortgage back against your approved draft. The balance due on closing should be checked against the amount set out in the approved statement of adjustments. The execution search against a mortgagor should be updated. And I point out that there is authority that you don't have to do such a search. I usually do it. It is important to remember the execution clearance is valid for only a certain period of time, especially in out-of-Toronto closings, and you must close within that time period or research. If you're closing out of town, you must fill out an envelope with your address, or you may be able to wait and pick up your documents. It depends on the various registry offices. What about after closing? There are payments that have to be made, and if the solicitor is to discharge any mortgage out of the balance due on closing, I suggest that the purchaser's solicitor be directed to make part of the funds due on closing payable to the mortgagee. The vendor solicitor should always have available a covering letter, to be delivered to the mortgagee, and the check inserted, obtained from the purchaser and inserted into that letter, and immediately after the closing, deliver to the mortgagee the funds and obtain a receipt. And this way you are avoiding any further interest charges. The same procedure should apply to any other amounts undertaken to be paid out of the closing funds. Obviously, to protect himself from his own client claiming that he misdirected the funds, the solicitor for the vendor should receive express written instructions from his client. The balance of the real estate commission may be payable after closing out of the balance due on closing. And again, if the client has personally authorized you to do so, then that should be paid. Again, it is good practice to have a direction signed to that effect. And I query whether a direction in the agreement of purchase and sale is binding on the solicitor, as he is not a party to that agreement. The insurance and the taxes. With regard to the insurance, you should write to the insurance agent enclosing any release of interest of the insurance by mortgagees who have been paid, and request that the premium, if there is a refund of premium, be returned to the vendor. The tax department has to be notified so they change their records. And I think that we usually fall down on this, but assumed mortgagees should be notified also and advised that the ownership has changed, and a request made for any post-dated checks that they hold signed by the vendor. What about undertakings? The solicitor for the vendor must ensure that he completes his undertakings, and I refer you to my comments on undertakings earlier. There is in your workbook a follow-up after closing checklist, and I refer you to that as well. What about the reporting letter? I've divided it up into short reports and long reports. Courtesy and service dictate that the solicitor immediately after the closing must phone the client and tell him the transaction has closed. I also think that courtesy and service dictate that we prepare some kind of report to be available, if not later in the day, at least the next day. I tend to suggest to all clients that they pick up the check and short report at my office. I'm sort of nervous about the mails and they can lose things. The final report. The final report, though final, should not take too long to prepare. The final report is important because you are going to confirm any discussions and instructions and directions that were given to you by the client. A precedent, again, for such a letter is in the workbook. In this connection, the precedent reporting letter does not confirm the vendor's continued personal covenant with the mortgagee where a mortgage is being assumed, and I would add that into that report if, in fact, that situation existed. I know I'm rushing. Lots of time. What about the purchase? We can look at it in the same way as we have the sale, under preparations for closing, the materials and general comments, and then getting into a little more of the specifics. And obviously some of my remarks that I've made on the sale will apply equally as well to the purchase. Preparation, organization, and coordination. That's the way to avoid error and confusion, and that's the way to complete the transaction without having an ulcer. Purchaser must be given sufficient time to arrange the funds required for closing. And obviously, every attempt should be made to obtain the adjustments from the vendor's solicitor as soon as possible. This is very important for new-time purchasers. They've saved frantically for that first down payment. They're tight to the wire for the funds, very anxious to know what those adjustments are going to be. Once you have received the statement of adjustments, you should check it against the agreement of purchase and sale and do all the calculations for each adjustment, and then put your calculation onto the statement of adjustments and tape it on so that you have proof that it is accurate on the machine, not using your head only. If there are errors, they should be reported to the vendor's solicitor and a request made for an amended statement. You want an amended statement available to go into your report to your purchaser. After the statement of adjustments has been checked, it is my practice to add to that the balance due on closing, the fees and the disbursements, and I prepare a letter setting out these amounts, including a copy of the adjustments, and request the client to bring in a certified check for the full amount. I think it's probably a good idea to put down disbursements that are estimated as estimated disbursements, those that have not been paid yet. If you have done, as pointed out in an earlier lecture, and explained to your client, as I said, a first-time purchaser especially, the fact of adjustments, fees, and disbursements, he shouldn't be too startled by your letter. It is my experience with regard to monetary matters that there should be open, complete, and full discussion ahead of time to avoid any misunderstandings. Again, the practice is to have the purchaser arrange his own insurance, and he should be advised in that regard. And if there is a mortgage back, to try and have a copy of the policy available on closing, showing the vendor's interest. Again, if we have these things ahead of time, we don't have to undertake. Directions. If the purchaser has decided to take title into the name of some other, or jointly or independently, he will be required to sign a direction to that effect. Should the purchaser have instructed you earlier to proceed in the transaction without the benefit of a survey, you're going to have an acknowledgement, and that has to be executed by him. I suggest that you not only have an acknowledgement, that he understands what's happening when there's no survey, but he also direct you to close the transaction without the survey. Any other matters discussed during the course of the transaction where you were instructed to complete the transaction despite certain problems should also be acknowledged in writing, and a written direction prepared and available for execution. I don't think we need one as thick as Bob's requisition letter, but you sort of know what I mean. Undertakings and declaration of possession. On all purchases, as a matter of course, I always request a declaration of possession for registry closings, and if there are chattels involved, an affidavit from the vendor that the chattels are free and clear. In the event that there are title problems that can be cleared by a declaration of possession, I prefer to use my own declaration of possession rather than using the pre-printed form. Then I can state clearly, in my own words, what I want said to make sure that title problem is cleared up, hopefully cleared up. I further prepare and forward to the vendor's solicitor for execution by his client an undertaking with respect to adjusting the statement of adjustments, and I refer you to that undertaking. It's in the workbook. The documents which must be executed by the purchaser on a purchase will include the affidavit of land transfer tax as to the value of consideration and residency. The deed may have to be executed if the purchaser is to assume any covenants, and there may be assumption agreements and agreements not to encumber as well. Arranging the file very similar to the sale, a review of the file a number of days prior to the closing should take place. Probably a little more detail in arranging the purchaser's file. Any matters to be discussed with the client, again, should be set out in a memo. All of the documents clipped together or in another place, in another folder, which have to be signed by the purchaser. It's important that you ensure that you have obtained satisfactory answers to your requisitions. And if you have not, now is the time to discuss what you will require on closing with the solicitor for the vendor, so that you will be in a position to inform your client before he attends, or when he attends, and obtain his instructions with regard to any outstanding items. Besides the requisitions pertaining to the title, you have made other inquiries as well. You should have satisfactory replies for each of these inquiries and update orally any inquiries that are not available right away, such as utility bills, taxes, mortgage payments. These things are paid just immediately prior to closing, and you're going to have to update them orally. And I suggest that you make a note of the person's name giving you the information and the date of that information. Again, it's my practice to have the purchaser attend at least a day prior to closing. And in my letter to him asking for the funds, I also suggest to him that he make an appointment with my office for that day before closing, and he may be required to bring his spouse with him depending on whether or not consents are required. The statement of adjustments should be explained to him in detail, and I always check his certified check against the amount of the calculations in my file. The purchaser must sign the land transfer tax affidavit, and it should be explained to him before the oath is administered. The purchaser's valuation of the chattels must be realistic, as he is swearing to the truth of that valuation, and I again refer to my earlier comments with regard to the execution of documents. It is my practice to search all executions at the time that the search is done, and then it's only a matter of updating the search of executions against the vendors on the closing date. If the transaction is closing on a very busy day and a large amount of time has elapsed since the time that I had the search completed, it is prudent then to do a sub-search a day or two before closing. Take out all the instruments affecting your title and not already in your search, and note up your search. Again, all documents should be checked for registrability, and a phone call or attendance at the registry office prior to closing for pre-clearance is most beneficial. Any problems arising out of the title and other inquiries should be discussed and written instructions obtained from the purchaser before closing the transaction. Not only should you require a written undertaking to close if there are outstanding items, but also a written acknowledgement signed by the purchaser indicating he understands his legal rights and obligations. I keep stressing that it's important that you anticipate any problems which may arise on the closing so that you can discuss them with the purchaser ahead of time and obtain his instructions. You'll still again want to contact him by telephone if in fact the problem arises, but again he will be in a better position to understand what you're saying and to instruct you. Stress with him the importance of being available on the closing date. And when I'm acting for the purchaser, I don't like to receive a key. I like the purchaser to have the key at the real estate agent's office or at a neighbor's, and I like him to go and pick it up there. If you do receive a key on closing, it's rather difficult if you've got other transactions to be back at your office in time, and the purchaser is usually very anxious to move in, and it causes a lot of problems. I think it's also important to remember that you may have to have the purchaser reattend your office to execute further documents after the closing, and I say that with regard to a bill of sale. Checks for the purchase of land or discharges of mortgages have to be certified, and then we go on to closing this horrendous transaction. Again, the closing memo. Excellent because it's a checklist for things to be obtained, and I refer you to my earlier remarks on it. The closing memo on the purchase should contain instructions for conducting the sub-search and search in the fee book, as well as for updating the execution search against the vendor. It should provide information as to new registrations that may be expected as answers to requisitions. And again, be sure to contact the solicitor for the vendor prior to closing to see how he requires the checks to be drawn for that closing. What about the closing steps? Each item of the statement of adjustments should be checked against the proof that is offered by the other solicitor. If your money is being used to discharge a mortgage, check the mortgage statement signed by the mortgagee. Check any discharge of mortgage being registered on closing against the mortgage and abstract it, and ensure that you receive the discharged mortgage. Do a personal property security registration search. I understand in Toronto you do it in a different building. In the country, we do it in the same building. Make sure to obtain any fees required to discharge or register instruments. Later, check the deed against your approved draft and also your copy. Obtain the names and addresses of mortgagees, and of course, obtain the declaration of possession, and as Bob says, be sure to file it as a deposit. If you must take an undertaking, then when possible, require as many of the following as possible: written authorization from your client, hold back funds as security for performance, ensure, of course, that the undertakings are in writing, and impose a time limit. If the undertaking concerns a discharge of mortgage, pay the amount required out of the balance due on closing directly to the mortgagee and obtain a mortgage statement addressed to the purchaser. Ensure that there is consideration for the undertaking. Obtain the key and have the vendor solicitor phone and have the balance of the keys released, if any. Deliver up your check and your mortgage back, and then you and the vendor should check the description of the deed against the mortgage. When you register, make sure you register in order. After closing of the purchase, again, you're going to have certain steps that have to be done. A letter to the tax department setting out that the sale has occurred to ensure that tax bills and assessment notices reach the new purchaser. Undertakings, very important after closing when you have obtained undertakings from the vendor or his solicitor. There must be a follow-up procedure. And to ensure that the undertaking is fulfilled, we do have that fabulous thing called the tickler system, and it allows for a regular follow-up. Do not close out your file until the undertakings, if any, have been fulfilled. What about reattendance? I mentioned to you with regard to the bill of sale, you're going to have the purchaser reattend to execute the bill of sale if you want to have it registered, and you've got about 5 days from the date it was signed by the vendor to have the purchaser attend and execute that bill of sale. Reporting letter. I again refer you to my earlier comments with regard to the short and final report. In the short report with regard to the purchaser, a written interim report should follow the day after closing, letting the purchaser know what bills he must pay very quickly. There might be a realty tax installment due. There may be a payment on the mortgage. You might also want to enclose extra keys to him. A lot of solicitors state that they don't have time to do that report, and I suggest to you that you're going to have time spent on the telephone explaining these things to the purchaser anyway. You might as well set up a system of a short report. A final report should follow very shortly thereafter, and I make comment about my remarks with regard to the sale. It is a record in writing as to the dealings between the solicitor and the client, and it should fully confirm those dealings in case of any dispute later. This report is also the solicitor's opinion as to the title to the property purchased, and there is a final report in the workbook when acting for the purchaser. I'd like to now look at some of the documents with regard to the factual situation. And I know that Miriam is dying to know what happened to Irma. I didn't like her very much, Irma, I mean. And I tried to get rid of everybody so that I would have a very simple executor's deed. Let's look at the rural property, and I believe you have an executor's deed in the workbook at page 129. Given the factual situation, I made some probably very outrageous presumptions, but I was trying to make it easier on myself by that time. The facts did say that there was an implied power of sale, so I don't know whether we have to make the deed pursuant to the Devolutions of Estates Act. I think we've got power in the will to sell, hopefully. I also would like to point out that I assumed that our friend John Fastbuck, deceased, did appoint in his will, therefore keeping the two uses situation so his wife's dower would not attach. And so I don't have our dear old Irma joining in this at all, which might have to have been if he hadn't appointed in his will. With regard to the beneficiary, Mary Jones, I don't even know if she's a beneficiary. I know that she is one of the executors. She, I had decided, would stay on the property, and our developer purchaser would take the property subject to the lease. So I don't even have her husband joining in the conveyance either to give up his spousal interest in the matrimonial home. What else did I assume? If you don't find an affidavit under the Planning Act, I assume that we got a committee of adjustment consent because we didn't get all of that property that we originally were contemplating. They obtained a consent and we only purchased part of the lands. And our purchase price stayed at $190,000. And the other assumption I made the assumption that the executors were not selling the property in order to pay debts, and therefore I don't have the spouses of the executors consenting with regard to the conveyance of this property either. I'm sure that most of you know how to fill out the executor's deed. It would be Joseph Smith and Mary Jones, both of the city of Brampton and the municipality of in the regional municipality of Peel, the executors of the last will and testament of John Fastbuck. He would be inserted there, and late of the city of Brampton in the regional municipality of Peel. They are the grantors of the first part. Cowardly Developments Limited, a company incorporated under the laws of the province of Ontario and having its head office at the city of Toronto, would be the grantee. I then have inserted the information with regard to his death, the probate of his will, with the surrogate court of the Judicial District of Peel, the dates, and there was no estate tax consent, and that goes out. I did state that further whereas that we were selling for the purposes of administering the estate of the deceased, but not for the purposes of paying debts, to ensure that the spouses of the executors did not have to sign the deed. And then a legal description of the property followed. The releases and the covenants have to be changed to the plural, and then the executors sign with seals at the bottom. I did insert an affidavit for my executors to sign stating that the recitals were true. I didn't think that we wanted to wait for 20 years so that they would be deemed to be true under the Vendors and Purchasers Act. I'm not going to go through all of the documents on the rural property sale, but I think I might mention that if you are buying a business and you are buying goods, crops, livestock, and so on, I query whether or not the transaction should comply with the Bulk Sales Act. And you might want to think about that and maybe obtain a statement as to seller's creditors and file same with the county court clerk. Bill of sale, of course, for the chattels, and register that. The personal property security registration system. A declaration of possession. This is registry office property. Of course, the person that would sign the declaration of possession, I would suggest to you, would be the daughter of John Fastbuck, one of the executors, and she would be signing as his daughter and stating that, to the best of her knowledge, information, and belief, possession of the property was as follows. I think that in my declaration of possession, I did say that the lands were fenced, and I set out the tenancy of her and her husband. I think it's important, if you'd like to turn to page 202 to look at your long closing memo, and maybe we could go and pull out some of the things I would put in my short closing memo if I was acting, let's say, for the purchaser. So we're acting for the purchaser of the rural property, and we're preparing a short memo to attach to the file. And again, I assumed that there was a mortgagee and he had a solicitor, and we had to meet him on closing, and that would be the mortgagee for the Farm Credit Corporation. And I asked that the purchaser's solicitor obtain from the vendor's solicitor, of course, the deed, and if the Committee of Adjustment consent had to be attached, then it would be, or stamped on it, a bill of sale, a direction and undertaking executed by the vendor, declaration of possession. I suggested that there might be a statement and affidavit under the Bulk Sales Act, of course, the key, and any special instructions with regard to requisitions. I stated that the tax bill in my statement of adjustments, there was a first installment paid, and you'd want a receipt for that, and any old title documents. I then suggested that the purchaser's solicitor deliver up to the vendor's solicitor a check, and we're going to have two checks because part of the funds are coming from the mortgagee and part of them from the actual purchase file. So I put a little asterisk and said refer down further into the closing memo for that second check. I then suggested that the purchaser deliver up to the first mortgagee's solicitor a copy of the statement of adjustments, a copy of the tax certificate and the receipted first installment, the mortgage in duplicate, of course, post-dated checks, fire insurance policy, and I think there was in the factual situation a collateral chattel mortgage. And then the solicitor would obtain from the mortgagee's solicitor, of course, the certified check and hand it to the vendor and obtain an address for mortgage payments. And then we'd have to register the documents. Just quickly, because I guess we're over time, you might want to look at the documentation for the urban property, in particular the transfer land titles. It's at page 176. This transfer is a transfer with spousal consent, and Era Black would be signing it. And I think that you should look at the affidavit as to age and spousal status, and I'll show you where I insert that line. If you read that affidavit, you'll see that we were each at least 18 years old, and then I insert, we had each read Section 1F of the Family Law Reform Act 1978. And then it goes on, and within the meaning of Section 1F of the Family Law Reform Act, we were spouses of one another. You can also insert, we were permanent residents of Canada. I believe that you may, next week, be getting some of the documents fully completed, and you'll be able to look at them at that time. Thank you.
Thank you very much, Pat, and thank you all for being so patient, even though we did go out over our time. I'm glad that I don't have to fill out all those documents all at once. Next week, we'll see what happens when the deal doesn't. Night.